The family institution can be considered as the most essential unit in any society. Within the family, the importance that should be given to children is of paramount importance. Children can be understood and children can be considered, to be more specific, as the present and also the future of any society, any state, or even the whole wide world. Hence, it is quite justifiable that special consideration should be given to children to ensure their proper development and also to ensure that they will be able to reach their optimum potential with as much as less barriers as there can be. Hence, it is the duty of any state to ensure protection for their children and also to ensure fair opportunities for them to develop by mitigating negative aspects that there may be which affects their development in a negative way, and also by strengthening the positive aspects that are around children in terms of their development. Thus, today's presentation will be based on one such aspect in terms of children's life and their development. Greetings to everyone. I am Harsha Vidhanapatirana, here today to do and to engage in a brief dialogue regarding the effectiveness of sections 308A and 341 of the Penal Code of Sri Lanka in terms of mitigating the impact that corporeal punishments can have in the lives of children to an effective and an efficient manner. So with your permission, let me proceed into the next aspect of the presentation. Within the research, the main issue that is considered is about the effectiveness of Section 308A and Section 341 of the Penal Code in terms of mitigating corporeal punishments to children. So in terms of this research, the main focus is on the punishments that are imposed to children within the school premises. Thus, within the process of the research, the sections will be used with the relevant case laws to see as to whether the sections can be used in an effective manner to mitigate the use of corporeal punishments and thereby eliminate the negative repercussions there may be in the development of children as a result of corporeal punishments. So in terms of the presentation, the first would be to give an idea about corporeal punishments and then to be thorough with the objectives and the procedures used to analyze within the course of the research, and then of course to see as to whether there should be any improvements made to the relevant sections in terms of their aspects or in terms of interpretations, and also to evaluate other options that there may be and also other matters that are incidental to the same. So in terms of children, in terms of getting a glimpse of the issue, it is very much important to understand the obligations that any state or a society has in terms of children. So in terms of children, the United Nations Convention on the Rights of Child can be considered as something that gives a very specific guideline or set of guidelines regarding the obligations that a state should have or the state would have in terms of ensuring proper development of children. So if you consider about Article 27, Article 16 and Article 37, among the other articles, it gives an idea about the special place that any state should have within its affairs to ensure proper development of children, not only physically, but also in terms of spiritual aspects, moral aspects, social aspects, and mental aspects. And if special emphasis is given on Article 37A, it is clearly visible that the state has a responsibility to ensure that students or children in general are not subjected to torture or any sort of inhumane, degrading treatment, which kind of goes in line with our fundamental rights in terms of freedom from being tortured as well. So in terms of children, what kind of a role does corporeal punishments have in terms of their development? Which leads us to the consideration of the objectives and approach of the research. So in terms of the approach and the objectives, the research has intended and attempted to identify as to what is meant by corporeal punishments, which basically is any sort of physical punishments. And then it tried to also understand the connection between corporeal punishments and the development of children as well. Even the World Health Organization, in its reports, has clearly mentioned the negative repercussions and effects there may be in terms of subjecting children into corporeal punishments. So in terms of the research, the main consideration would be on the schools. But apart from that dimension also, the same principle or the same matter can be duly seen and expected as well, which is why, as a justification, the research can be supported, or the importance of the research can be supported in such manner. Thirdly, the main task was to consider the effectiveness and the competency of sections 341 and 308A in having this much needed deterrent effect in terms of imposing corporeal punishments, especially within the school system. One of the justifications that can be used in terms of mitigating corporeal punishments, as I mentioned earlier, is or would be the overall negative impact or the effects there could have been or there can be in terms of a life of a child after such punishments are made. Research suggests that corporeal punishments can actually play a negative and also a very active role in terms of the dignity of the child. Sometimes they can be stressed regarding that. They might feel guilty. They might actually experience loss of dignity, which can actually lead to more and more severe repercussions, which also can end up in suicide, which makes this not so trivial. And then, of course, the final objective would be to see whether the effectiveness guaranteed by these sections is sufficient, or to see whether there are any other options, or to see whether any other developments can be made to ensure the effectiveness of these sections and thereby mitigate cruelty against children, especially by way of punishments. So in terms of the analysis, as you can see in the screen at the time, Section 308A, which was introduced by the Penal Code Amendment Act number 22 of 1995, which specifically states whoever who has custody, charge, or care of any person whose age is under 18 years, which means a child, willfully assaults, ill-treats, neglects, or abandons the child, or anything whatsoever relating to that, can be guilty of a punishable offense. And if someone asks, is there an issue as such in Sri Lanka? The statistics that can be obtained by the National Child Protection Agency, it clearly suggests within the year of 2020, for instance, more than 2,000 cases were reported under Section 308A only, which actually helps us to understand the importance of addressing this issue of corporeal punishment and also cruelty against children. In terms of the section, however, there are different interpretations given by the honorable courts of our country, especially in terms of the President Muhammad Mustafa Pais versus the Attorney General. The term willful was considered as moot. Willful means basically that you have the proper means or you have the proper understanding to reach a very specific end. So that means if a certain teacher punishes a child in the school system, and if the child is going to be negatively influenced by it, be it an injury or a mental injury or a physical injury, it really questions the competency of this specific section. As to why? Because whether the teacher intended that to happen or not, which was the moot point in the case that is being considered, which also questions as to whether the section can be used in a proper way to address all incidents involving punishments for students in the school system, because the counter argument would be that the actions were not willful, or it can be considered as rough way of disciplining a child, which could be an issue. And the same is analyzed to a very significant extent within the course of the analysis section in the research as well. Considering about section 341 as well, which actually involves situations where someone uses intentional force without another person's consent to engage in some sort of a crime, or even to engage or to provide an idea of injury, fear, or annoyance, or causes one, which is considered as criminal force. This actually is quite related to the school system as well, because basically the main idea behind imposing punishments would be to impose this deterrent effect as well. The fear for punishments can actually play a role in terms of a student's life as well. But the problem is the overall impact that it might have in the life of the child. But if you consider about illustration I in the same section, it actually gives an idea. If a schoolmaster, for instance, exercise reasonable discretion as a teacher and flogs a certain student, that will not be considered as engaging in criminal force as per this section. So this actually gives us a perspective as to the classical beliefs on the corporeal punishments in my perspective. But the harmful impact needs to be addressed in a more lenient way as per the requirements of the current day society as well. So this can be in a certain way considered as a way to normalize corporeal punishments in the school system, but the term reasonable is moot, which actually gives an opportunity for the court to interpret as well. But both the sections combinedly and individually gives certain protection for children, especially in the school system as well, but at the same time leaves a bit of a room to some form of ambiguity at the same time as well. But there is no guarantee that these sections will not be effective in addressing such situations, but there is a bit of a doubt on the same aspect as well. So before concluding, I would like to kindly convey this factor in terms of fundamental rights as well. So in terms of criminal law, where the intention is to punish offenders, but there are other aspects of law, branches of law that can be used for the purpose of addressing such issues as well, which actually comes under fundamental rights jurisdiction as well. So the Bandara versus Wickramasinghe case law provides an insight as to the extent where which, among other rules, extent within which punishments can be imposed as well. So therefore, a punishment that is provided by a teacher can also be considered as falling within the executive or administrative actions, and thereby will give a chance for an aggrieved student within the schooling system from corporeal punishments to go and secure remedies through the Supreme Court of the country as well under fundamental rights, which is a very positive attribute. But the competency of the other provisions in terms of penalizing individuals who engages in such behavior in punishing students should be considered to a significant extent. In that sense, reporting of incidents, the mechanism should improve, and then a degree of specificness or certainty needs to be injected, and a question arises as to whether strict standards in terms of the requirement of mens rea or the intention in engaging in punishments needs to be considered in all cases, or whether it should be relaxed at the same time as well, which is discussed within the course of the research. So thank you very much for the opportunity that you have given me in terms of giving and sharing an insight about the research. I hope it might have provided some insights to you within the day, and I hope it is academically important to all the readers as well. So thank you very much for the opportunity. Have a great day, and I wish you all the best and all good things. Thank you very much.